You could spend months building a brand, investing thousands of dollars into it, and watching it grow into something incredibly valuable, and still discover that you don't actually own the rights you thought you did. Sounds impossible, right? Unfortunately, it happens more often than you might think. Before you spend a single dollar registering a trademark, hiring a lawyer, or filling out an application, there's one question you need to answer. What exactly are you trying to protect? It sounds like a simple question, but it's one that countless entrepreneurs get wrong. Some people believe they need a trademark when what they actually need is copyright protection. Others assume they need a patent when their invention doesn't qualify for one. And some spend thousands of dollars protecting the wrong asset while leaving the most valuable part of their business completely exposed. That's why, before we talk about applications, registration procedures, or legal fees, I want to make sure you understand what intellectual property really is, and more importantly, which type of protection applies to what you've created. And I want you to stay with me until the end of this video, because I'm going to give you the advice that, in my experience, 99% of the people talking about intellectual property on the internet never tell you. Think of it as a little trademark secret. Don't worry, I won't ask you to register the secret, at least not yet. But seriously, this advice that could change the way you think about protecting your business and your intellectual property. So let's start with the basics, because once you understand this foundation, everything else will make a lot more sense. Intellectual property is often treated as if it's one single legal concept, but it isn't. Think of it as a toolbox, where each tool has a specific purpose. If you need to tighten a screw, you don't reach for a hammer, and if you need to cut a piece of wood, you don't use a wrench. Intellectual property works exactly the same way. There are different legal rights designed to protect different types of creations, and choosing the wrong one can leave your business vulnerable. The four main types of intellectual property that every entrepreneur should understand are trademarks, copyrights, patents, and industrial designs. Each one protects something completely different, and understanding those differences is the first step toward protecting your business properly. Before we go any further, let me encourage you to do one thing. If you haven't watched the channel trailer yet, I highly recommend that you pause this video and watch it first. It's only a few minutes long, but it explains one of the biggest misconceptions people have about intellectual property and why understanding that misconception changes the way you think about protecting your business. As I mentioned in the trailer, we live in a world of more than 8 billion people. With that many people on the planet, similar ideas are inevitable. Just because someone creates something similar to yours doesn't automatically mean they stole it. Sometimes two people can independently arrive at remarkably similar ideas without ever knowing the other person exists. Keep that thought in the back of your mind as we continue, because by the end of this video, you'll understand why that matters, and more importantly, what the law actually protects. Let's begin with trademarks. A trademark is designed to protect your identity in the marketplace. It tells consumers who made a product or who provides a particular service, allowing them to distinguish your business from everyone else. A trademark can include your business name, your brand name, your logo, a slogan, and, depending on the laws of the country, it may also extend to distinctive packaging, sounds, colors, shapes, or other identifiers that have become associated with your business. When you walk through a supermarket, you don't need to examine every product to know which one comes from Coca-Cola, Nike, Apple, or Samsung. You recognize those brands instantly because their trademarks represent a reputation that consumers have learned to trust over many years. That's the purpose of a trademark. It doesn't protect your invention, your product, or your business idea. It protects the identity that consumers associate with your goods or services. Now let's move on to copyright. Copyright protects original creative expression rather than ideas themselves. Books, music, films, photographs, paintings, software, architectural works, articles, videos, marketing materials, and website content are all examples of works that may be protected by copyright. One of the most common misconceptions is that copyright protects ideas, but that's not how it works. Imagine asking 100 writers to write a story about a detective solving a murder. The underlying idea is identical, yet every author will produce a completely different story. Each writer owns the copyright in the story they created, because copyright protects the way an idea is expressed, not the idea itself. Understanding that distinction is essential, because it's one of the most misunderstood principles in intellectual property law. Before we move on, if you're finding this series useful, I'd really appreciate your support. A simple like helps YouTube recommend these videos to more entrepreneurs, inventors, and creators who could benefit from them. And if you don't want to miss the upcoming lessons, make sure you subscribe, because this series is designed to build your knowledge step by step, and every episode builds on the last. The third major category is patents, which generally protect inventions and technical innovations. A patent may apply to a new machine, a manufacturing process, a medical device, a chemical composition, or another technical solution that satisfies the legal requirements of the country where protection is sought. Patent law is one of the most complex areas of intellectual property, and the requirements differ from one jurisdiction to another. In many countries, an invention must be new, involve an inventive step, or be considered non-obvious, and be capable of industrial application before it can qualify for patent protection. If you believe you've developed something that may be patentable, timing becomes extremely important. Depending on the country, publicly disclosing your invention before taking the appropriate legal steps may affect your ability to obtain patent protection. That's why understanding the rules before revealing your invention can be just as important as the invention itself. The fourth type of intellectual property is industrial design protection, and it's probably the least understood of the four. Industrial design rights generally protect the visual appearance of a product rather than the way it functions. They can apply to the shape, configuration, contours, ornamentation, or overall appearance of a product, provided the design meets the legal requirements of the relevant jurisdiction. Imagine you've designed a luxury chair with a completely unique appearance. The engineering mechanism that allows it to function could potentially qualify for patent protection. The name under which you sell the chair could be protected as a trademark. The photographs in your catalogue and the promotional videos advertising it would likely be protected by copyright. Finally, the chair's distinctive appearance could potentially qualify for industrial design protection. The same product can therefore be protected by several different forms of intellectual property, each covering a different aspect of what you've created. Now, this is the advice I really wanted to give you, and honestly, it's something you probably won't hear from 99% of the gurus out there. Most of them will tell you one of two things: do it yourself, or go hire a lawyer. But here's the part they don't tell you. Sometimes, the smartest person to hire for your IP isn't a lawyer at all, it's a specialized IP agent. Why? Because an IP agent lives and breathes this stuff. They deal with trademarks, patents, and registrations every day. They understand the process, they know that requirements can change from one jurisdiction to another, and they know how to navigate the problems that can come up along the way. And here's another advantage. A good IP agent has lawyers in their arsenal, so if your situation ever requires legal representation, they already have trusted lawyers they can bring in. And because of those professional relationships, you may even be able to get preferential rates. So when the gurus tell you, hire a lawyer, or just do it yourself, remember there's a third option, and in many cases, it may be the smartest one. Everything we've discussed today forms the foundation for the rest of this series. Once you understand the purpose of trademarks, copyrights, patents, and industrial designs, you'll start to see your business very differently. Instead of asking, how do I register a trademark? You'll first understand what you're trying to protect and why that particular form of protection matters. And if you found this video valuable, I'd really appreciate it if you shared it with someone who's starting a business, launching a brand, or working on an invention. Because the more people understand intellectual property before making expensive mistakes, the better prepared they'll be to protect what they've created. And if you're enjoying this series, don't forget to like the video and subscribe so you don't miss the next lesson. Because in the next episode, we're focusing entirely on trademarks. We'll talk about what makes a trademark strong, what makes one weak, what can and can't be registered, and the common mistakes that can prevent an application from succeeding. So, if you're serious about building a successful, sustainable business, I'll see you in the next lesson. And as always, protect what's yours.